Welcome, everyone. The oversight hearing of the Subcommittee on Disability Assistance and Memorial Affairs will come to order. We are here today to examine the appeals process for veterans' disability claims. Our goal is this hearing is to learn more about the process that is currently in place, identify the areas that need improvement, and look for ways to improve overall efficiency, whether that be by changes in the law and rules or in practice. I anticipate that our VA panelists this morning will provide information on each of their respective roles in the appeals process from the regional office, the Appeals Management Center, and the Board of Veterans Appeals. I thank all of you for coming today. I also look forward to hearing from the court, and I especially thank Chief Justice Caswell of the U.S. Court of Appeals for Veterans Claims for taking the time to be here this afternoon. Thank you so much. To date, we have heard quite a bit about the backlog of veterans' claims, the VA's concerted efforts to transform the people, process, and technology of the claims system. However, what is not clear is the level of attention that VA is paying towards veterans' appeals. Recently, VA has instituted a series of initiatives to clear out its oldest claims, and these initiatives require months of mandatory overtime for its employees. Through these measures, VA proposals to complete about 300,000 of these old claims in a very short order within a matter of months. When a claim is initially decided, it becomes a number in a VA's Monday morning report. It is considered a win towards the department's numeric goals for 2015. Yet we know that the Board of Veterans Appeals projects a workload of over 100,000 appeals in the next fiscal year alone. In fact, many experts have cautioned that VA will soon be encountering a tsunami of appeals. Earlier this year, the full committee raised concerns on VA's ability to anticipate and prepare for challenges in the processing of veterans' claims for disability benefits. And with this potential influx of appeals, VA cannot ignore this process, of course. They must be adequately prepared. We know that right now, every step of the appeals process is plagued by lengthy delays. For those who may not be familiar with the appeals process, here's how it works in general. After a veteran receives an initial rating decision, they may file a notice of disagreement with the regional office. In response, the regional office will either reconsider the claim or uphold the original adverse decision and issue a statement of the case. The statement of the case outlines the decision, provides a list of the evidence reviewed, and attaches a list of the laws and regulations applicable to the decision. A veteran who is dissatisfied with the SOC may file a substantive appeal within 60 days. If a veteran chooses to file a substantive appeal, the claim is sent to the Board of Veterans Appeals, a semi-independent agency within the VA, for review. This review is performed by VA attorneys and board members, sometimes referred to as veterans law judges, who may allow the appeal, deny the appeal, or remand the case back to the RO for further development. Pursuant to statute, appeals that are remanded require expeditious treatment by the RO. It is of note that prior to 1988, the BVA's decision was considered final and was not subject to any form of judicial review. In 1988, Congress passed and President Reagan signed into law the Veterans Judicial Review Act, creating the United States Court of Appeals for Veterans Claims, an independent Article I court with exclusive review of denials from the BVA. Just as a veteran aggrieved by a final decision of the BVA can appeal to the CAVC, a veteran aggrieved by a final decision may appeal to the federal court and ultimately the United States Supreme Court. Appeals that are remanded through the federal court system are also statutorily required to receive expeditious treatment. Despite the statutory requirements, appeals claims are often placed on the back burner in favor of initial claims. The 2012 BVA's report of the chairman states that the average length of time between the filing of an appeal and the decision by the board is 1,040 days. If a veteran subsequently appeals to the CAVC and the Federal Circuit, they might wait nearly twice as long. Thus, you can imagine this committee's surprise to learn that appealed and remanded claims were not to be included in VA's oldest claim initiative. Although VA stated that their priority is to provide initial decisions to veterans who have been waiting for 2 years or more, many veterans with appealed or remanded claims have been waiting much longer than that. Unfortunately, lengthy wait times are not the only problems currently plaguing the appeal system. In March 2013, the federal court issued a ruling stating that the VA acted unlawfully in 2011 when it promulgated a regulation that eliminated certain procedural and appellate rights for veterans appearing before the BVA and ordered VA to show cause as to why sanctions should not be imposed. VA responded to that order on May 20th, 2013 with a path forward to restore these rights to those veterans affected, and it is my hope that VA takes veterans' due process and appellate rights more seriously in the future. Our nation's veterans deserve an appellate system that promptly and accurately adjudicates claims that may have been incorrectly decided by VA initially, and that gives appropriate and timely consideration to remanded matters. The Veterans Appellate process is a multi-tiered process that spans from the RO to the BVA to the CAVC and beyond. It is my hope that bringing witnesses from each stage in the process together at today's hearing that we may better understand the role each plays in the process and work together in a more efficient manner to process veterans' appeals. And before I conclude my remarks, I want to highlight that the role of technology in the appeals process cannot be ignored. There has been much discussion on the need for seamless technological capabilities between DoD and VA. Similarly, VA must ensure that the technology that it has developed, the Veterans Benefits Management System, or VBMS, is equipped to not only meet the needs of ROs, but also those needs of the BVA. Although the VBMS development team has met with BVA staff, we have heard conflicting reports as to how well the BVA's needs have been received and incorporated into the VBMS to date. I encourage VA to continue communications with the board to ensure that VA's technology upgrades also meet their needs. With that, I'd like to welcome our witnesses. Today's scheduling was slightly compressed due to various events. Ordinarily, we would hold separate panels with VA on one panel and the court on another. However, due to time considerations today, we're seating a sole panel, and the order of the testimony is meant to be indicative of the appeals process. We will start at the regional office and work up to the Court of Appeals for Veterans Claims. First, we have Mr. Keith Wilson, the Director of the Roanoke Regional Office. He is here on behalf of the Veterans Benefits Administration. Welcome. Then there is Ms. Laura, I hope I get this right, Eskenazi. Yes, Eskenazi, the Principal Deputy Vice Chairman, is here representing the Board of Veterans Appeals. Welcome. Finally, in terms of VA representation, we have Mr. Ronald Burke, Jr., Director of the Appeals Management Center in the National Capital Region Benefits Office. Then we will hear from Chief Justice Bruce Casal, who is here representing the U.S. Court of Appeals for Veterans Claims. We also have numerous statements for the record that have been submitted from various organizations. I'd like to thank all of those who submitted them for today's hearing. With those introductions complete, I'm eager to hear from all of our witnesses on how we may improve the overall process for Veterans Appeals. I thank you all for being here today. And now I'd like to yield to my good friend, the ranking member, Ms. Titus, for her opening statement. Thank you.
Thank you, Mr. Vice Chair, and I want to thank Chairman Runyon for holding this important hearing and tell him that our thoughts and prayers are with him in the loss of his dear friend. I also want to thank the witnesses for coming today because this is a very important topic and a natural transition from the things we've been focusing on up to date concerning the backlog. We've heard a lot of testimony, a lot of personal stories, a lot of statistics from the VA about the backlog. But now we need to address what's becoming increasingly important to us is a possible backlog of appeals that seems to be getting worse and potentially will get even more serious as we deal with the backlog of original claims. I routinely hear from veterans in Southern Nevada who say they are just waiting far too long to receive a decision not just on their claim, but on any of their appeals. So improving the speed and efficiency of the claims process and the appeals system will be an important step that we can take towards trying to recognize the brave men and women for all that they have sacrificed for our country. We often have heard in these hearings from the VA about a transformation that's taking place at the department, and I commend them for that, but it's important that we see that translated into real-time, real-life results for our veterans. It was promising to hear one VA official suggest that the VA is now at a tipping point of breaking the claims backlog, and I know that some numbers are coming out that show that indeed progress is being made. However, I know that the veterans in the Las Vegas area don't feel like we've reached that tipping point. The veterans in Nevada, along with 4 counties in California who are served by the Reno Regional Office, are quite frustrated by the length of time that it takes them to hear from the VA on a final decision. We're one of the worst in the country, and the average time is 530 days. That's far from the 125-day goal that's been set by Secretary Shinseki. I'm pleased that General Hickey visited the Reno office and reports back now that progress is being made and more staff has been hired and some of the additional regional offices are helping with the backlog. But more needs to be done, and it needs to be done faster. So while I'm encouraged by the progress, let's not just rest on our laurels. In the past 45 days, as a result of providing provisional ratings and clearing the inventory of old claims, the total number of pending claims has dropped by 44,000, and the number of backlog claims has dropped by 74,000. So again, kudos to the VA for rolling out the VBMS, if I get all these initials right, at all 56 offices ahead of schedule. That was great. So I'm pleased with that progress. But I think that all that focus on the dealing with the backlog of claims is going to lead to a decreased focus on dealing with appeals, and that's the purpose of today's hearing, to be sure that doesn't happen. VBA has surpassed 250,000 claims waiting on appeal, and BVA has 45,000 claims pending. The average length of an appeal completed in FY 2012 was around 1,000 days, as the Vice Chair pointed out. There's progress, but there's still room for improvement. What really concerns me is that assuming the VBA does its work through the current backlog by 2015, this could lead to a significant increase in the number of cases that are waiting for resolution of appeal. By the BVA's projections, the workload will more than likely double by FY17 from approximately 45,000 claims today to more than 102,000. This is further compounded by the fact that we have been made aware that VBMS is not ready for use by the BVA. So I, like the Vice Chair also, that when he spoke of technology, I urge the VA to take the necessary steps to ensure that VBMS is also functional as quickly as possible. It's counterproductive to send electronic files to the BVA in a format that results in more delays for our veterans. So the intent of, I think, the shift of this committee from focusing on the backlog to focusing on the claims is not to rob Peter to pay Paul. We don't want to resolve the backlog at the VBA only to create a new one in the appeals process. So we've got to figure out how to do both without one harming the other. So I look forward to hearing your testimony and hope that you will give us some recommendations so that we can help you and we can produce the best outcomes for our veterans who are appealing their RO decisions. So thank you for allowing me to speak, Mr. Vice Chair, and I yield back.
I thank the ranking member, and now I'd like to recognize the panel. Your complete written statements will be entered into the hearing record. And Mr. Wilson, you're recognized now for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Titus. My name is Keith Wilson. I'm the Director of the Regional Office in Roanoke, Virginia. I'll describe the appeal process as it occurs at the regional office level. Any decision, a final decision that VA makes on veterans claims is an appealable decision within 1 year of notification of that decision. The manner in which veterans can appeal that decision is flexible by design. They can write a specific letter to us telling us specifically what they disagree with. They can just tell us they disagree in general terms. The point of the flexibility in the program is to make sure veterans are afforded every opportunity for a favorable decision and allow them to get satisfied in the most expeditious way. Veterans can appeal either an entire decision that we make on a claim or various issues. By that I mean we make a decision on a claim, but often the claim will have multiple disability issues that we adjudicate. So a veteran could file an appeal for one decision or 10 decisions that we make, again, completely up to them. Additional information is often identified when a veteran does file an appeal for the claim decision that was denied. We do have an obligation to go out and collect additional evidence if it's identified at any time in the process. And we are very happy to do that because we are trying very hard to resolve the appeal at the earliest opportunity in the appeal process. Throughout the process, it's an open record. We have the opportunity to grant the decision in full or grant the appeal in partial or continue to deny the benefit and ultimately send the case to the Board of Veterans' Appeals for decision. When the veteran does file a notice of disagreement with us and a disagreement with the decision, the first thing that we do is provide them a letter providing them an overview of what we call the decision review officer process. The decision review officers in our facilities have the opportunity to complete a de novo review on that case. In other words, they can look at the evidence of record and based solely on the evidence of record without any new information, they can render a different decision on the appeal. So they could grant the benefit at the regional office level through that process. Many veterans do find it advantageous to follow the DRO process. Not all of them, but many of them do ask for that. If the claim cannot be granted at the DRO level, then we issue a statement of the case to the individual. The statement of the case lays out in great detail the decisions that we made on each of the issues under appeal, all the appropriate regulatory guidelines, statutory guidelines, etc. So it's a very large document often, but it provides all the details on the decisions that we've made on his or her claim. If the veteran continues to disagree with the decision on their claim after reviewing the statement of the case, the veteran provides to us what we call a substantive appeal. In other words, they notify us that, yes, they've read the statement of the case, they continue to disagree, and they want the appeal to continue. They have several options at that point concerning hearings. Once we receive the statement of the case, technically the case at that point is under the jurisdiction of the Board of Veterans' Appeals. Oftentimes, veterans will ask for a hearing when they submit their substantive appeal. Those hearings have different options. A veteran can ask for a hearing with a BVA member in Washington. They can ask for a video hearing with a board member from our office, or they can ask for a travel board hearing. Members of BVA conduct travel board hearings at the regional offices around the country on average a couple times a year. If the veteran does decide that that's the option they want to pursue, then they will be placed on the docket for when and the next available slot would be for the travel board hearing. Anytime during that process, if additional evidence is received, we will review that evidence. If we can grant the claim, the appeal, we will do so. If we're unable to grant the appeal, then we will issue a supplemental statement of the case. So again, the veteran receives all the evidence that we used in deciding the claim. Once that is completed, then we will certify the claim to the Board of Veterans' Appeals, and I'll defer to my colleagues for the next step in the process.
Thank you. Good afternoon, Chairman Bilirakis, Ranking Member Titus, and members of the subcommittee. Thank you for inviting me to speak to you today on the very timely and important topic of the Veterans Disability Compensation Appeals System. This appeals system operates in several stages within VA. Most of the stages in the appellate process are conducted at the VA regional office level within the Veterans Benefits Administration. The board's work on an appeal does not begin until VBA completes all initial appeals processing actions and certifies and transfers the appeal to the board for a final agency decision. This multi-stage system is why I am accompanied today by both Mr. Wilson and Mr. Burke of VBA. The board's mission is to conduct hearings and dispose of appeals properly before the board in a timely manner, and to provide veterans with one review on appeal to the Secretary. The board has a very unique role in VA. It provides a de novo, or new look, at each case being appealed from the regional offices, which includes a review of every single piece of evidence in the record. The decision made by the local regional office receives no deference from the board. Each decision of the board must contain written findings of fact, conclusions of law, and a detailed explanation. Board decisions read like legal appellate briefs, including legal citations that support the outcome in the appeal. Board decisions can range from 20 to 40 pages in length, depending on the complexity of the case. Board staff attorneys draft about 3 decisions per week on an annual basis for review and signature by one of 64 Veterans Law judges. Each Veterans Law judge signs generally 752 decisions per year. The board decides appeals in docket order, which means that the oldest appeals are worked first. This method ensures that the veterans who have been waiting the longest have their appeals heard first at the board. Looking over the past 2 decades, the amount of evidence associated with each appeal has been steadily rising, as are the number of issues per appeal, which results in longer, more complex board decisions. Even with this growing complexity, veterans have enjoyed an unprecedented level of success at the board in recent years. In fiscal years 2011 and 2012, the board allowed benefits in 28% of the appeals it decided, the highest allowance rate in the past 2 decades, and far higher than the allowance rate of only 13% back in 1990. In fiscal year 2012, the board denied benefits in only 22.5% of the appeals it handled. That's far lower than a denial rate of 62% back in 1990. In fiscal year 2012, where the board was not able to allow a benefit, the board remanded or sent back to VBA 45.8% of appeals for further evidentiary development to ensure that all procedural protections have been provided to the veteran and that all relevant evidence is obtained. Despite this remand rate, there is a success story to be told concerning remands. Remands are, in large part, the result of VA's efforts to do everything possible to help the veteran substantiate his or her claim for benefits and to ensure that no potentially favorable evidence is overlooked. Remands fall into 2 categories: avoidable remands and unavoidable remands. Unavoidable remands, which make up the majority of remands today, are the result of the pro-claimant open record that allows new evidence to be submitted or obtained up until the end, the point that a final decision is made within the agency. Through intensive training, VA has seen success in reducing the category of avoidable remands from a high of 60% back in 2005 when we first started tracking this data to 36% fiscal year to date. With the predicted rise in appeals in the coming years, the board continues to work with its partners in VA as well as external stakeholders to seek efficiencies in this complex appellate process. I look forward to answering any questions you or the members of the subcommittee may have. Thank you.
Thank you, Ms. Eskenazi. I appreciate it very much. And now, Mr. Burke, you're recognized for 5 minutes.
Thank you. Good afternoon, Chairman Barakis, Ranking Member Titus, and members of the subcommittee. As Director of VBA's Appeals Management Center, I direct the operations of an authorized staffing level of 249 full-time employees. The Appeals Management Center was established in 2003 as a centralized remand processing facility, and currently approximately 75% of all of VBA's remands are processed by the AMC. The AMC receives appeals as they are remanded to us by the Board of Veterans' Appeals. Upon receipt, personnel initiate development actions as directed by the remand order. Once all necessary evidence is obtained and the file is ready for decision, rating veteran service representatives or decision review officers will render a disability determination. If the decision results in a continued denial, or if benefits have not been granted in full, the AMC issues a supplemental statement of the case and subsequently recertifies the appeal back to BVA after appropriate due process has been served. For cases that result in a full grant of benefits sought on appeal, veterans' decisions are promulgated at the AMC so that benefits can be expedited before returning the claims folder to the RO of jurisdiction. By expediting action on remands, the average days pending for veterans that have appeals at the AMC has been reduced from nearly 400 days down to today's 110 days. In January of 2012, the AMC established a partial grant processing team. This team was established in order to expedite the promulgating of benefits for veterans that had received partial grant decisions on appeals that also contained remanded issues. From date of inception to current, the partial grant processing team has served more than 3,380 veterans, delivered more than $63.5 million in retroactive benefits, and has issued those benefits on average in less than 17 days from receipt of the remand from BVA. In addition to the processing of remanded appeals, the AMC began brokering in more than 200 notices of disagreement from field offices in February of 2013 and increased that monthly brokering level to 500 notices of disagreement per month beginning in April 2013. This effort was established to assist VBA in improving processing timeliness for notices of disagreement. I appreciate the opportunity to provide remarks on this very important topic and look forward to any questions that you may have for me today. Thank you.
Thank you, Mr. Brooke. Appreciate it. And now, Chief Judge Casal, you're recognized for 5 minutes, sir.
Thank you very much, Mr. Chairman, Ranking Member Titus, and distinguished members of the committee. I'm pleased to appear before you today. I commend the committee's effort in working to ensure that veterans receive decisions on their claims in the most accurate and efficient manner possible. With my statement being submitted, I'll just go over a few key points. For the first time ever, the court is fully staffed with 9 active judges, and we thank this committee, the other committees of Congress, and the President for your support and continued support. In fiscal year 2012, the court received 3,649 appeals and disposed of 4,355. The court is one of the busiest federal appellate courts based on the number of appeals filed and decided per judge. We are maintaining our productivity through the tireless effort and focus of our entire court staff. The court continues to evaluate and modify its procedures to streamline the judicial review process to the greatest extent possible. To this end, our pre-briefing staff conference process has been extremely successful in bringing the appellants and the secretary together to work out mutual resolutions of many appeals. On average, about 65 to 70% of the court's appeals are conferenced, and of those, approximately 50% end up being resolved by agreement of the parties, generally with a remand. The court has also made administrative adjustments to assist chambers in providing prompt judicial review of fully briefed cases, such that the individual single judge decisions are generally decided within 90 days after they get to the judge.
We've also worked with our central legal staff attorneys to streamline their case review process, a process that at one time had 800 cases waiting to be sent to chambers, and now all those cases are sent to chambers under 30 days as an average. These efforts have gained efficiency and cut days out of the procedural development of claims while preserving for each veteran who appeals to the court the right to a full and fair decision. Despite the court's efforts to streamline its appellate review, the bottom line is litigation is time-consuming, and affording parties due process adds to the overall wait for decisions on appeals. Cases settled during the conferencing process, for example, still take about 6 months. Cases that go through the full briefing take a little over a year for the single-judge decisions. 245 days are those without any requests for extensions. That's the time to file briefs, to get the record, to review the record, etc. We also have about 5,000 requests for extension in each of these cases, which on the cases decided by judges averages about a little over 2 requests for extension each, and generally those requests for extension are for the 45 days each, so it's an additional 90 days, if you will. That's just the process to go through to allow everyone the time to file their briefs, review the record, etc. The court continues to encourage appointment of a commission to evaluate the costs and benefits of the unique 3-tiered federal appellate review system we have for veterans' benefits decisions. And on that summary, Mr. Chairman, I'll rest and take any questions that you have.
Thank you. Thank you very much. I'll now begin questioning and then recognize the ranking member and other members, of course, alternating in order of arrival. The first question, I don't think the chairman's arrived yet, so I'll start. I'd like to start by thanking the witnesses here today, of course, here today, as well as the VSOs who submitted written testimony on this troubling topic. The scrutiny, this is for the entire panel, the scrutiny of the backlog is often data-driven, and we know that VA keeps track of statistics on initial claims such as days pending and average days to complete. However, VA's Monday morning workload reports only keep track of the number of appeals pending. In other words, there is no indication of the average days pending or days to complete for appealed and remanded claims. My question is, why doesn't VA make these statistics publicly available via its Monday morning workload reports? For the panel, who would like to begin?
Mr. Chairman, I'll take a shot at it. It's a little bit difficult for me to provide a full answer because I'm really speaking on behalf of the Roanoke Regional Office. Certainly that information is available, and I think it's fair to say that if there's a desire to have that information available, it would be made available. But I would defer to anybody else that might.
Why wouldn't it be published in the reports, the Monday morning reports? Any reason for that?
None that I'm aware of, no, sir.
Kept by the Veterans Benefits Administration, so I'll defer to my colleagues on that. I will note that the board does track its workload. We don't publish it on a regular basis externally. We publish our annual report that shows the trends. Currently at the board, our cycle time, which is the time that it takes on average from when a case comes into the board and leaves the board, is 117 days. If you include the period that we allow our VSO partners to review the appeal and provide written argument, that portion is a total of 251 days of processing time at the Board of Veterans' Appeals level.
Anyone else?
To that, sir, that I can't speak to the Monday morning workload report. However, all of VBA's appeals processing times at all of the different cycle times in the process are posted by our performance analysis and integrity staff and accessible by RO leadership, so we do have those numbers available to us.
Thank you. Next question, again for the entire panel. To any of the VA witnesses, could you elaborate on the policy reasons behind excluding appealed and remanded claims from VA's recent initiative to address oldest claims? Oftentimes, these claims end up an ongoing cycle of being appealed and remanded several times, as you know, causing veterans to wait many years for a final decision on their claim. The law requires that claims that are remanded from both the board and the Court of Appeals for veterans' claims receive expeditious treatment. Mr. Wilson and Mr. Burke specifically, could you describe how this process works in practice at both the regional office and the Appeals Management Center, respectively? Did the Appeals Design Team pilot program offer any solutions as to how to more efficiently process remaining claims in an expeditious manner?
Sir, I can speak to the Appeals Design Team. As the lead for VBA's Appeals Design Team, we did do a year-long appeals process review in the Houston Regional Office. The study of the data from that year-long pilot are still being analyzed, very productive results. The process did lead to a whole host of recommendations that were designed at improving processing efficiencies as well as quality. Those recommendations are still under review, and we hope to be able to get some of those best practices and recommendations deployed to help improve the processing timelines, as I said, as well as quality.
Mr. Wilson?
Unfortunately, I don't have detailed information concerning the pilot. Roanoke was not part of that pilot. I think it's fair to say, though, that the manner in which VA tracks its work, specifically concerning the 2-year effort on oldest claims, was never intended to provide a slide of any kind to any of the other workload, including appeals. It's just simply a manner in which we chunked out the work to move forward.
Thank you. Next question. Yeah, one more question, yeah, and then we'll move on. Many of the statements for the record that were submitted for today's hearing emphasize the need to simplify the appeals process. If you had the ability to redesign the Veterans Benefits appeals process, what would you do differently for the entire panel?
I can speak from the regional office level, and the issue of complexity in the system is very important. As I mentioned in my original discussion, the process itself is open. Evidence can be added at any time. It's an interactive process. We take any kind of indication from the veteran that they're dissatisfied as an appeal. The process by design is meant to try to grant benefits whenever possible for the veteran. And that's what we try hard to do. But that does lead to a complex process. It leads to a process where there are oftentimes circles in the process as you're going out and getting, for instance, additional evidence. Ultimately, that would be a good thing if we can grant benefits, but it does take a long time in the process.
Anyone else? What would you do differently?
Sir, the board has put forth a number of legislative proposals, each of which we think will add to efficiencies in this complex process. I don't know that there's a silver bullet, but several of our legislative proposals are targeted towards efficiencies, particularly at the board level. One of them concerns changing or altering the requirement for the optional board hearing, allowing the board to default to scheduling through video, and then offer an in-person if the veteran requests the in-person hearing. That proposal has had some traction of late, and we're hopeful that that can move forward. We've also identified a proposal to alter the type of content in the board decision. As I stated in my opening statement, the decisions have become lengthy and complex, and if we could simplify the content, that could perhaps lead to some efficiencies without taking away from rights of veterans. We also put forth a legislative proposal on a jurisdictional matter, identifying the substantive appeal as a requirement for triggering the board's jurisdiction as opposed to an optional requirement. And another good success story I would like to report is the board had put forth a proposal about a waiver requirement. In other words, the system is set up that the veteran gets several bites at the apple. And at the point that the veteran files a substantive appeal at the regional office level, if they submit additional evidence at that stage in the past, the RO had to relook at that and issue a supplemental statement of the case. With the Camp Lejeune Act, which was passed in 2012, there's a provision that became effective in February 2013 that would allow that evidence to come straight to the board for review. Because it's so recent, we haven't had the opportunity to appreciate that success, but we believe we'll see a lift in efficiencies from that.
I would add to this, sir, that there are several things right now that VBA is using, that further utilization will help with the appeals process. VBMS, it's got some inherent benefits to that from a quality perspective, but also gives VBA the ability to work subsequent claims at the same time that an appeal is being worked, thus eliminating any delays based on trying to process both the subsequent claim and an appeal. Continued use of DBQs, I think, will also lend the quality aspect and lead to more accurate decisions. Further utilization of fully developed claims should also cut down on the appeals workload, and standardization of forms. Specifically, one that came out of the design team was a notice of disagreement form that would make it much easier to review a submission by a veteran or an accredited representative to tell that that's in fact a notice of disagreement. As we did the design team pilot, we noticed that many of the notice of disagreements that were put under controls untimely were because they were hard to decipher whether or not they were a subsequent claim or a notice of disagreement. So some of those would help with our appeals process as well.
Chief Judge Casel.
Thank you, Mr. Chairman. I would support, I believe it's this committee's proposal that a commission be developed. I think it's a very complex issue on a system that has been developed rather piecemeal over a significant amount of time with judicial review over the last 24, 25 years. You have 2 de novo reviews down below. They take time. You have reopening at any time of a claim. You have Q against old board decisions at any time. You have 2 then appeals of right at the judicial level. This is a system that allows a veteran many opportunities to submit additional evidence. And I'm not suggesting that that's wrong, but when you weigh that against time, you have to take that into consideration, it seems. I look, and I don't have any apologies for the Secretary, but and don't know his operations down below, but 1.3 million claims being processed. That's one level. That's the initial claim. As I understand it, the board has somewhere around 50,000, maybe going up to 100,000 over the next 4 years, which, as a side note, could really impact the court also because we're a derivative thereof. But that's about 5%, a little less than 5% of the claims that get to the board. And then of that, 4% of the claims that get to the board get to the court. So you have 2 different systems. One is that initial claim, how do you get it processed, how do you get it processed in a timely manner. And then you have all these protections, if you will, for the veteran to allow him to have a second de novo review, to reopen a claim 10 years later, to go against a 20-year-old claim and seek Q, to have 2 judicial reviews at a federal appellate court. So I would support the committee's approach towards this. I think it's this committee, that a commission be created to take a look at that system.
Thank you very much. Now I recognize the ranking member, Ms. Titus, for as long as she wants. I know we don't have a lot of time, but maybe we can, again, when we reconvene, you can continue.
Well, thank you, Mr. Vice Chair. I'll be brief. I just I appreciate your testimony. I just want to step back and try to look at the big picture. I appreciate all of this that you've laid out of ways that you're addressing the backlog and reducing the number of cases, BBMS, virtual docket for scheduling, video conferencing, this pilot program that you mentioned, appeals design team. That's all great, but it seems to me we're looking backwards. We're always reactive in the VA, figuring out how to deal with the problems and the cases that already exist there. We've got to anticipate, I believe, a great increase in the number of appeals that y'all are going to be hearing over the next couple of years. I mean, we've just been hearing all the things that have added to the number of original claims. We're dealing with the 2-year cases. Then we're going to deal with the 1-year cases. You got the Vietnam veterans who are now in the system. You got the veterans from the wars that are winding down in the Middle East coming into the system. You've got increased complexity of the cases that come to the system. You've got a greater proclivity to litigate everything in society. Are you ready for this? This is an onslaught. I don't hear any of you talking about the need for more space or more lawyers or more training or, you know, this is coming. Are we going to now come back in 5 years and talk about what we're trying to do with dealing with this after the fact as opposed to getting ready for it, knowing that it's coming? Anybody want to address that?
Ranking Member Tice, I'd be happy to take that question. At the Board of Veterans Appeals, we predicted that this fiscal year we would receive 54,000 appeals, and so far we're at 37,000, so we're on track to meet that prediction. It's not very different from past years. In 2010, we received 52,000 appeals. So the incoming for us is in the outer years, but they're coming, and we are working to gear up to meet that challenge. We're in discussions with the Secretary about internal resources, and we are actively hiring a great number of attorneys, executing every dollar in our current budget to get new attorneys in, doing a new type of training with them to hopefully have them hit the ground running, and to think of new ways to do what we've been doing to be ready for this large increase of appeals that are coming.
It doesn't give me a lot of confidence. You're not giving me very many specifics here, but at least you recognize it's a problem. Anybody else?
I can assure you that if they go to 100,000 claims or are on track for that over the next several years, I or my successor will probably be here discussing with you the additional need. What has happened actually in the last couple of years is the number of appeals from the board has actually gone down to the court slightly. And so with the 2 additional new judges that we received at 9, we're now working with that. They take about a year to get fully up to speed. And we're constantly reassessing how each of that is, how they react with that, with the appeals that are coming in and the number of judges that we have. On the numbers that they have, I think that we are well-staffed. The committee has always been very supportive of the court. As their numbers go up, if they do, which I think everyone thinks they will, we will be assessing that and coming back to the committee. Thank you.
Okay, Mr. Chairman, thank you. I may come back.
Okay, very good. We'll give you another opportunity if I'm still the chairman. We expect Chairman Runyon to return after the break, but we have 3 votes, and we'll go ahead and recess now and hopefully return by around approximately 3:15. Thank you. Thanks for your patience.
Subcommittee will come to order, and I want to thank everyone for coming back and apologize for not being here earlier. I was attending to some personal, I had a college roommate of mine pass away over the weekend, so we had a funeral back in Ann Arbor. It was a rough one, but thanks for coming back. I'm going to ask a few questions. I don't know if anybody from the minority or the majority may. I know Chairman Miller may stop by here. But first question is actually going to be for Mr. Wilson. In 2011, U.S. Government Accountability Office investigated the VA's DRO review process with a report entitled Clear Information for Veterans and Additional Performance Measures that Could Improve Appeals Process. GAO made 3 recommendations for VA action, which were revise sample appeals, election letter within the policy manual and test the letter's clarity with veterans. Secondly, establish national and regional office performance measures related to the appeals resolution at the regional level and ensure sufficient quality review producers are in place. And third, assess the knowledge and skills that the DROs need to perform their job and developing a training program tailored to the DROs. And are you aware of what action the VA has taken on these recommendations since 2011?
Unfortunately, I'm not familiar with the specifics from a national perspective. I'm able to talk at the Roanoke level concerning the performance metrics. We do have performance metrics in place. Those are national measures, but concerning the specific recommendations of the report, unfortunately, I'm not able to address those. I don't know if Mr. Burke could, or we'd be certainly happy to take the information for the record and provide a response.
Do you have anything, Mr. Burke?
Yes, sir, I do. I know that currently VBA is in the midst of negotiating revised DRO performance standards, and it was a recommendation of the appeals design team to look a little more closely at the de novo review as opposed to traditional election. We're still analyzing the results of a year-long pilot. We hope to have the analysis completed here shortly, so that we can put forth our ideas or suggestions about the utilization of the de novo reviews compared to traditional election.
There's a long list of things I would love to get to, but respectful of everybody's time. And I'm going to butcher your name. Ms. Eskenazi? Yes. Can you state for the record what specifically the board needs to do in order to process appeals in VBMS?
The board has been working with the VBMS team in VBA since the inception of the VBMS, which is the new robust system. We had virtual VA, and we're moving into the VBMS. So we've been working on that work group for several years now. We have an extensive list of programming requirements, and to date the focus has been on gearing up VBMS for processing the large number of claims that the department has seen. And now we're shifting into the appeals work. To date, the board has received less than 10 appeals certified to us in the VBMS system. I think it's actually 8, and they've all come from the Appeals Management Center. They're cases that have previously been to the board. We remanded to the Appeals Management Center and VBA for additional work, and they are now aggressively scanning, and they've returned 8 to us in this system. We've done our initial training in May, and we're in the process of ensuring that all of our staff have the necessary clearances through the IT officials to access that system. We have about 1/3 of our staff with the access currently. We've also identified the top 4 programming requirements that we would like the VBMS team to focus on ensuring that we get in the 6.0 release. I'm told on Friday, my understanding is that the board's top 4 requirements are scheduled to be in that 6.0 release. So that's scheduled for late in the year. In the meantime, we've identified methods of working those VBMS claims, working around what we don't currently have programmed in until the point that we have those programming requirements and can be working at a higher level of efficiency. We're looking forward to getting our hands into the system. So far, we've only done a pilot with inactive appeals to kind of see what it looks like. So we're looking forward to working these active appeals to continue to refine our requirements.
So it is safe to say that as far as VBMS goes, we're even further behind in the appeals process than we are in adjudicating new claims.
Well, we haven't seen any appeals yet. Like I said, these first few just came in the past few weeks. And it's actually good timing now that we have the access. We're going to work them. We're going to take detailed notes on the effectiveness of the system and continue to work with the programming team to refine those requirements.
Because it's kind of, I'll just put this out there because, and I was going to get to this a little bit earlier, because in the metrics in the VA, I think a lot of times, and I raised this question in the full committee hearing a couple weeks back, especially in the process we're in the middle of right now of adjudicating these older claims, the new old claims, which I questioned. Mr. Rubens, I think, actually tried to answer the question, but because there weren't medical exams being given on the newer claims, which raised the thing that they would be appealed because there could be new evidence in the time that they were sitting there, which would kick all of this back again to the appeals process. And now shifting what you would say a backlog in the front end to a bigger backlog in the appeals process. And this is really, I think, what this committee's fear is that because of our reporting mechanisms in the VA, we're not so much concentrating on the backlogs in the appeals process. And I think Judge Castle will say that it's growing. And I think with the process and the new direction of getting these older claims out of the way is going to add a little bit to that. I think that's my belief. I don't know if anybody on the panel would kind of see that happening.
Mr. Chairman, I can address that from the Roanoke perspective. First of all, one of the heavy lifts for us in Roanoke in order to get these oldest non-appeal claims out was getting the medical exams. We did not cut corners on getting medical exams. We ordered a lot of medical exams, and that was really one of the long poles in the tent in terms of getting these claims done timely. So I can assure you we did not cut corners in terms of getting exams for those veterans. The other thing I can say is we are not letting this effort for the 2-year claims interfere with our ability to continue to work appeals. We have not peeled off any of the people from our appeals team or quality team to do those 2-year-old claims. Now, nationally, we have implemented a mandatory overtime policy, which does include the people in our appeals team and our quality teams. During the mandatory overtime, those employees are working on the 2-year initiative. But when they're doing their regular core hours, they are continuing to focus on quality and appeals.
Well, and I think we all agree. I mean, getting it done right the first time eliminates the appeals process a lot of times. But I think past history is going to say a lot that there's potential that we have an issue in the appeals process as we move forward. And I'm just wanted to make sure that we're all aware of that, because I think sometimes as we're moving forward, yeah, it sounds all great in the Washington Post every week, but in reality, we're creating another problem. And it's personally frustrating to me.
We're not interested in robbing Peter to pay Paul. We are not at all happy with the amount of time it takes to process an appeal. We're not at all happy with the amount of time it takes to process a claim. But I can tell you flat out that we are not robbing from Peter to pay Paul. We are focusing on both.
Yeah, and I get that, but as we go through and we do this, I mean, some of the metrics we use, I mean, I believe the measures and appeals is average 1,040 days to get processed, if I'm correct.
Sir, I'd like to address that time frame. The appeal system in VA is a multi-stage process. That particular 1,000 days process is the point that the veteran completes the formal appeal action at the VBA RO level, files their Form 9, and the board completes its action. At the board, when we get our hands on the case, we're turning them around in 117 days. If you count the time that our VSO partners have to review that case, then we're turning them around in 251 days. One thing, as VBA takes in more claims to serve more veterans with benefits, it naturally will lead to more appeals. Veterans have a right to an appeal, and there's been studies on correlations of quality between the appeal rate, and it doesn't, high quality stations may have high appeal rates, so there's not really a correlation there. If you look back over trends, generally the board gets about 5% of what VBA takes in that year. So we're taking those numbers that VBA is taking in and projecting the outer years, and we're predicting an increase in appeals. Part of the efforts that we're doing at the board to address that incoming rise in appeals, and I neglected to give the details on this when Ranking Member Titus asked this question earlier, we're doing an aggressive hiring campaign, and we're hiring 100 new attorneys between now and the end of the fiscal year. That's a significant proportional increase in the board staff. We're trying to get these people in, get them aggressively trained, and gear up for that future load that we see coming to the board.
And I think you kind of raised my next question, is that 5-step process I think we have to take a look at also. Because as we sit up here and talk about bureaucracy, there's potential for a lot of that to be happening there. And ultimately, hurting servicing our veterans. Really, I'm going to ask two more questions. Both be, actually one will be more of a recommendation of Judge Castle. As you noted in your testimony, the Court of Appeals for Veterans Claims has exclusive jurisdiction over denials by the Board of Veterans Appeals, and the court is one of the nation's busiest appellate tribunals. If you could give your fellow panelists at the board here one piece of advice on how to improve the quality of BVA decisions, what would that be?
I can only mention that what they already know, the number of remands that are sent back to the board primarily involve a reasons and basis or a medical exam or a failure to address favorable material. I do note that we get somewhere in the neighborhood of 8%, 9% of the cases decided by the board that are not remanded because they aren't going to be appealable at that time, that are appealed to the court. And there is about 70% that involve representation by attorneys. They go through the conferencing process that we've established at the court, and about 50% of those are settled by the attorneys for VA, Group 7. And so at some of the functions that we've had, I have mentioned that perhaps Group 7 could be incorporated within the training that the board does, and I think they may have actually done that, if I'm not mistaken, because they can share their insight into the cases that they see within VA and the negotiations that they have in that conferencing process. Just focusing on those three errors, though, I think would be helpful, obviously, to see if you can identify them ahead of the time before they get to the court would be helpful in both the remand rate where the Secretary's Council agrees and then also when they ultimately get to the judges.
Kind of talking in that same in that same line of thought there, you noted in your testimony the number of appeals that come to the court unrepresented, but that acquire representation during the course of their appeal. Could you comment on the effect that a representative can have on the quality and nature of the appeal moving forward?
I don't have any statistics per se, but just in reviewing the cases, lawyers generally frame the issues better than the veteran does. That's why we require all of the cases that involve representation by counsel to go through the conferencing process. That process requires the counsel for the veteran to identify the issues on appeal, to bring those issues, share them with the Secretary's Council, they're not here at this hearing, and then to go to a conference with our central legal staff. That process, because the issues have been identified by counsel, I think is part of the significant reason why you have the 50% remand rate, because they are being identified by counsel, explained to the opposing counsel, the Secretary, with discussion of our central legal staff, and you get a 50% remand rate. We see that in the briefings that come in. You have a fully briefed case by counsel to explain those issues on the cases that get to the judges, versus a page where many of the veterans are really expressing dissatisfaction but not identifying error. So if they can get representation, I would say it's probably beneficial to them to do so. And there's the active pro bono program that provides representation through that process, and that's why at the end I think it's somewhere close to 70% are represented.
Well, again, I want to thank you all for being here and for coming back and allowing me to get a couple questions in. So I would like to again thank you all for your testimony, and looking forward to continuing to work with each and every one of you on these important matters. With that, you are all excused, and I want to thank everyone for being with us today. I look forward to future updates on the initiatives we have heard about today, and look forward to working with all of you throughout this Congress to ensure we improve veterans' disability claims appeals process. I'd like to again thank all of our witnesses for being here, and ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include any extraneous material. Hearing no objections, so ordered. I thank the members that were here earlier for their attendance today, and this hearing is adjourned.